Hi, my name is Andrew Kinney. I'm an attorney that practices Social Security law at Hoglund Law Offices. Today I wanted to do a video to help people understand what to expect when you're testifying at a Social Security hearing with a federal Social Security administrative law judge. There is a lot of fear about talking in front of a judge, particularly when it involves benefits that are very important to you. The Social Security hearing itself is the first real time you get to discuss your case with a decision maker. Hearings can vary across the country. In my experience since 1992, one of the things, the patterns I've noticed, is that hearings are generally about 45 minutes to an hour. In that time, you have a Social Security administrative law judge that speaks directly with you about what's wrong with you and finds out essentially how you're affected day to day based on your limitations. So what I generally tell people when I'm going in front of a hearing, going to a hearing with one of my clients, is I explain first to be yourself. Nothing is more important than having the judge understand that when you're there, you're being real with the judge. Nothing is worse if someone thinks that they need to say certain things to make them sound worse. The medical records that are in the file and that your attorney gets before the hearing are locking in what's wrong. The person that shows up at the hearing to explain his or her situation, my client, is only there to give detail. That's what I tell people, because it's in their own words and they need to explain it in their own way. Another thing that I think is very important about a Social Security hearing is that you get enough sleep, you make sure to appear ahead of time so you're not rushed and distracted. You should also make sure that if you're in a hearing and you may have family members that witness your hearing, make sure that they're not perhaps with good intentions interrupting you or trying to make sure that you include certain things. I tell my clients that these hearings are not tests, they're not something that if you don't say the right thing you're going to lose. What's most important, again, is that if you're talking about something that the judge has to understand how bad it is, if you're talking about pain, the judge needs to understand how bad the pain is, where it is, when it happens. Now, this may all be reported in the record, but this is a time where you can talk to the judge directly and make your point that, for instance, with a back problem, that you cannot bend down. If you have spasms, how often they last, what do you do to make them better, if anything there is to do, do pain medications work? You can see that there are a lot of things to talk about at a hearing, and there's a lot of things you might want to fit in, but keep in mind, and this is what at Hoglund Law Offices we tell our clients, keep in mind that this is a basic time where you can lay out the basic reason you can't work full time. You get more detail than that, and it may cause some problems. If you have any other questions about your Social Security hearing, please feel free to call us. We help people before they've applied, after they've applied, when they have appeal pending. We even help them when they call us, but we do need time to get to help someone. If they're too close to a hearing, the first time that you have a hearing, you do have a right to postpone the hearing to get an attorney. But there's a time frame here. So if you're looking at this video and you have a hearing tomorrow, for example, just know that you, at least for the first hearing, have a right to postpone if you want representation. If you want an attorney with you, make sure that you ask for a licensed attorney and make sure who you call is a law firm, not an advocate firm or a non-attorney rep firm. And if you have further questions, you can call us at 1-800-850-7867, and you can also go online to check us out at hoglundlaw.com. Thank you very much.